everybody. Welcome to tonight's forum with our Supreme Court candidates. We're really excited. Should be a great event. I'm Tim Shield. I'm a professor of philosophy here at UW South. I'm also the director of the Menard Center for the Study of Institutions and Innovation. That's quite a mouthful. Menard CSII is probably what you would remember us by. We're hosting tonight. We have a number of co-sponsors. I want to acknowledge them at the start. So the Scout Student Association, the Center for Applied Ethics, Elizabeth Buchanan is the director, the League of Women Voters of the Greater Chippewa Valley.
That would be me as co-president and Anne Marie. Anne Marie McClellan as the other co-president, and we welcome and are so grateful for everybody turning out.
And the Honors College is another sponsor. I have a couple of comments about some of the technology in the room. Don't touch that black device in front of you. It's a mic and it will really mess up the system. The other thing is this is set up so that the video should follow the audio. So sometimes the screen should be showing us, and sometimes the screen will be showing Judge Karofsky and Madison. Sometimes there's delays in that transition, so a little patience for those few seconds in between the transitions. With that, I'll introduce Danielle Wagner, who graciously agreed to be our moderator tonight, and turn things over to her.
Thank you so much, Tim. As you said, I'm Danielle Wagner. I'm the evening anchor at WEAU 13 News, so I anchor the 5, 6, and 10 o'clock news. So if you do go home tonight and watch the 10 o'clock, I won't be there because I was here today. So thanks for getting me out of work. I'm privileged to be here to take part as the moderator for this judicial forum. Thanks to all of the candidates for being here in person and via video as well. Thank you guys so much, and thanks to you for being here to listen and to be informed voters. I think that's very important. And just to touch on that a little bit, I studied journalism, history, and political science at the University of Iowa. I studied political science not because I had aspirations of going into politics, but I knew in this profession I would always need an understanding of politics. And it's almost a little fitting, Tim and I were talking, that this is happening on the night of the Iowa caucuses. So a very political day. But again, thank you so much for being here. We want to keep things moving on time as much as possible. So I think we'll get underway here. I want to take time to introduce the candidates, and then I will let you guys know a little bit more about what the format will be so we can all follow along. And Grace here is in the front to help keep time so that I as well stay on time. Now, if you guys don't stick to time, I do have 4 dogs at home, so I'm very good at give a little, no, stop. That will be my response.
Don't hit me with the roll up this week.
I haven't ever done that yet. So again,
a 1 and a 30, so you don't have to get there.
Perfect, thank you, Grace. Again, thank you to our candidates. Justice Daniel Kelly is here to my left. He has served as a Wisconsin Supreme Court Justice since 2016. He was appointed by then Wisconsin Governor Scott Walker to fill the unexpired term of Justice David Prosser. Do you want to explain how this worked, or should we skip over that?
So just a short note on that. So it actually doesn't fill the unexpired term. The rule is that if you're appointed, you stand for election in the next spring election in which no other member of the court is on the ballot. So if you can figure that out, you can come and tell me when I'm wrong.
We have Professor Ed Fallone here on my right. He's a law professor at Marquette University in Milwaukee. Fallone was a 2013 candidate for the Wisconsin Supreme Court. And joining us via video link, we have Judge Jill Karofsky. She's a judge of Branch 12 of the Dane County Circuit Court in Wisconsin, and she assumed that office in 2017. So again, we're glad to have everyone here. Each is vying for a 10-year term on the Wisconsin Supreme Court. You guys are informed voters, so I probably don't need to tell you, but I'll have a reminder anyway. The primary is set for February 18th, and that is 2 weeks from tomorrow. So if you haven't marked your calendar, do that. Now, that will determine which two of the three candidates you see here tonight will advance to the general election, and that is on April 7th. So mark your calendar for that as well. So a little bit about the format tonight before we start with the questions. We'll begin with each of the candidates giving a 2-minute opening statement. After the opening statements, we'll move into the question and answer portion. I am here to ask the questions that I did not come up with, so don't give me any credit for coming up with the questions. The groups did that, so thank you, I appreciate it. For each question, each candidate will have 2 minutes to answer that question. At the end, you will each be given an opportunity to give a 1-minute follow-up, if you choose. The follow-up is not required, so if you don't have anything to follow up after all the candidates have gone, don't feel obligated, but that is your option. So we will continue this through each of the questions. We do have 5 questions with the option of a 6th, depending on how we're doing on time. So that will be dependent on if we get to that or not. Grace is here in the front, and she'll kind of be giving the cues of a minute for 30, and then wrap it up if you need to as well. So Judge Karofsky, hopefully I will maybe make hand motions as well so you can see. Since you probably don't see Grace, just to give you a heads up as to what the time is.
Thank you, I appreciate that.
No problem. And again, don't touch your microphones on your desks, otherwise you'll be chiming in on this as well. Do any of the candidates have any questions about the format before we get started? Okay. I will be changing up the order that I asked, just so the same person isn't going first every single time. But let's start with Justice Daniel Kelly, and with your opening statement. So you have 2 minutes for your opening statement. Justice.
Very good. Thank you so much. Thanks all for coming out. Thanks for everyone who's watching. I'd like to take just a moment to introduce myself. I know that Supreme Court races don't grab all the headlines that some others might. So just a little bit of introduction. I'm Dan Kelly. I am the proud husband of my wife, Elisa Kelly, who is here with me this evening. Please would you say hello? Thank you. We have 5 children that we've raised all their lives in southeastern Wisconsin, and they are a blessing to us. I was appointed to the court, as mentioned, back in 2016, after a long and broad history in the law. I've litigated in a lot of different areas. I've been in government service, I've been in the for-profit sector, I've been in the nonprofit sector. I've been a partner in one of Wisconsin's oldest and most respected law firms, and I've started a brand new law firm with friends. I've litigated, I've been a defense counsel, I've been a prosecutor, I've litigated contracts in UCC and banking and insurance and professional responsibility and constitutional law and administrative law. And in all of that, I've done my level best to serve the people of Wisconsin and the rule of law. And so as I've come to the Wisconsin Supreme Court, my commitment has been to continue that commitment, that passion for the law, and following the constitutional text within the role of the justice. Thank you.
Thank you, Justice Kelly. And Professor Fallone, I'll turn it over to you for your 2-minute opening statement.
Very happy to be back here in Menomonie and see all of you. I'm committed to going around the state of Wisconsin, every part of the state, and it's been a great campaign since I announced this past March that I was running for the Wisconsin Supreme Court. I'm not going to say it's difficult, but when I did announce in March, I was 6'4" and I had a full head of hair. Let me tell you about a client that I represented in the Wisconsin court system. She was a woman, a middle-aged woman, getting close to retirement age, co-owner in a family business. And it was a very successful family business. In fact, so successful that her co-owners, her relatives who owned the other part of the business, decided they wanted all the profits for themselves. And so they tried to push her out. In fact, they pushed her out of the business and they said, "We want to buy your stock. We're the only people who will buy your stock, and we're not going to pay you much for it. We'll pay you pennies on the dollar what it's worth, but you have to accept our offer. What choice do you have? And by the way, we've hired one of Milwaukee's biggest law firms with our company business profits. So what are you going to do? We dare you to sue us." Well, she sued, and I joined her legal team. And I knew what the big firm was doing because I had practiced for big firms for years before I became a law professor. And I evened the playing field. And she walked away getting paid what she was worth for her stock, over $10 million. Because I fight for the underdog. It's what I've done my whole career. As a law professor at Marquette Law School, I fought for the rights of free speech, of the Solidarity Singers protesting in the state capitol. I fought for getting working families, lawyers that they could get in the courthouse to help them. I fought for against the Muslim ban because I stand up for the underdog.
Thank you, Professor Fallone. And now let's turn it over to Judge Karofsky. You have 2 minutes for your opening statement.
Thanks, I just want to test the volume. Can you hear me okay?
Yes.
Okay, good. Good evening, everybody. I am really sorry that I'm not able to be with you up in Menomonie because I love it up there and it's beautiful. I am a single mom. I also was in court all day. I picked a jury this morning and I didn't get out of the courtroom until almost 5 o'clock. And we have not found a time machine yet in my campaign to get me to places as quickly as I would like to. So thank you very much for letting me appear this way. I understand it's not ideal. I also know that Wendy Sue Johnson has been kind enough to show up there to hand out some of our literature. I really appreciate it. If anyone has any questions, please get on our website, jillforjustice.com. Look, I'm running for the Wisconsin Supreme Court because we've got to get our Supreme Court back on track. I've been talking to people all around Wisconsin for the past several months, and they're concerned by what they see on the court. They see justices who do not follow the rule of law, justices who are making decisions before anyone walks in the state Supreme Court chamber. They see justices who are acting like politicians. And all of that feels like corruption to people. So I am in this race to offer my experience, my Wisconsin values, and my energy. As far as my experience, I'm the only person in this race who is or who has ever been a trial court judge. I have heard more than 1,700 cases last year. I see every day how the law plays out for real people in the courtroom. And that is important to have when you're thinking about who's going to be our next state Supreme Court justice. I also have experience being a prosecutor and a victim advocate. I was Wisconsin's first violence against women resource prosecutor, and I was also the head of Wisconsin's Office of Crime Victim Services. I help crime victims in every county in the state of Wisconsin get the help, services, and support that they needed. Those are the things that I'm going to bring onto the Wisconsin Supreme Court.
Thank you, Judge Karofsky. All right, shall we get started with the questions? Professor Fallone, I'll start with you, if that's all right.
Yes, it is.
Work our way through the group again. This first question has to do with constitutional interpretation. So, Professor Fallone, what principles of constitutional interpretation help you to begin your analysis of a case?
Well, I've been studying and teaching the Constitution for 25 years, and I've come to a very firm conclusion. There is no one model or set of rules for how to interpret the Constitution. There's no guidebook. But there are certain principles that I believe in very strongly. One is that our judges, when they're interpreting the Constitution, should have humility. Humility. We don't know everything, and we shouldn't think we do. Second, we should exercise judicial restraint. And something you don't hear much about nowadays or even see much in evidence nowadays, but it's the idea that when cases come before a highest court, whether it's the U.S. Supreme Court or the Wisconsin Supreme Court, if it's not necessary to reach out and decide a constitutional issue, you shouldn't do it. You can resolve the case on statutory grounds or because the facts aren't appropriate. You shouldn't reach the constitutional question. Judicial restraint allows our legislatures to be the primary policymakers and to make sure the courts do not intervene unnecessarily. Another principle I feel very strongly about, and this is where Justice Kelly and I disagree quite strongly. I'm a firm believer that our courts should follow precedent. They should let settled rules continue to guide our cases. We should not overturn prior decisions just because we think we know better. We think it was wrong. No. Settled cases should be followed, because when you overturn precedent, it turns every judicial election or every appointment into a political battle, because everything's on the table. And who wins that election or who gets that appointment becomes all important, because people are refighting old battles, and that's how politics gets into our courts. And I'm the candidate who's been running from day one to keep politics out of this race. And one way we can do that is by respecting precedent and not reopening previously decided issues.
Thank you, Professor Fallone. Judge Karofsky, same question. What principles of constitutional interpretation help you to begin your analysis of a case?
So I interpret the Constitution very, very often in my courtroom. I had to do it just as recently as a couple of hours ago. And when I do it, when I'm thinking about the Constitution and I'm interpreting it, I'm doing it with today in mind. It is 2020. We're talking about a document that was that comes from the late 1700s, a time when women like us didn't have the right to vote, where African Americans were only considered 3/5 of a person. It was a very, very different place where we lived back then. We couldn't have imagined having these handheld computers in our hands. So when I'm thinking about the Constitution, that's how I think about it, and that's how I interpret it. I agree with Professor Fallone when it comes to precedent. I think it's important to follow precedent. If we don't follow precedent, there is no stability or predictability in the law, and that erodes people's confidence in the law. They're unsure of what is going to happen, and it's a very, very big issue in the judicial system. When I hear words like Justice Kelly uses sometimes, where he talks about originalism, that really is code for I'm going to get at a predetermined outcome. And that is what we have seen in the Supreme Court in many of the decisions that he has, that he is saying that I'm going to interpret the Constitution as it was written, but really what happens is he ends up interpreting it in whatever way he needs to in order to reach a decision for the right-wing special interests. And that's what feels like corruption to people in the state of Wisconsin. What I do is I follow the rule of law in my courtroom every day. I look at what the law is, I look at what the precedent is, I look at what the Constitution says, and then I apply it to the facts of the case that are before me over and over and over again. And that is exactly what I'm going to do on the Wisconsin Supreme Court.
Thank you, Judge Karofsky. Justice Kelly, same question. What principles of constitutional interpretation help you to begin your analysis of a case?
Yeah, that's a great question. It goes to the very heart of what the responsibility of a justice of the court is. So it's pretty straightforward for me. We start with the constitutional text. So the principle is called textual originalism. You look at the words that were actually used by the framers, by the people who wrote the Constitution, and you figure out what did those words mean at the time that the document was adopted, and then you apply that meaning. So Judge Karofsky doesn't understand this principle. It is the exact opposite of coming to a predetermined conclusion. I don't come to a case with any predetermined conclusions. I look at the text, and this is the power of textual originalism. It prevents you from having a preordained conclusion in mind. You look at the text, you look at the original public meaning, and you allow that to lead you to the conclusion. The text always leads me, and I just follow. And that is the key. That is the primary distinguishing factor between me and Judge Karofsky. She doesn't understand that principle. She doesn't know what originalism is about. If you conclude that originalism is about coming to a predetermined conclusion, then you're missing the whole point of the doctrine. Now, Mr. Fallone and I, we've had numerous conversations about precedent, and we do have some disagreement there. Now, I respect what he says about not wanting to overturn precedents often. Sometimes it's necessary. What I do is I line up the law with our prior opinions, and if there is a difference, if they don't match, our sworn duty is to apply the law rather than our opinions.
Thank you, Justice Kelly. And I would like to offer a 1-minute follow-up if anyone is interested. We'll start with Professor Fallone. Do you need this mic?
I'm going to use this one mic for both.
All right, sounds good. If you would like a 1 minute. Now, I know we've talked a little bit about legal precedent, and feel free to keep that in your follow-up, but just so you know, that is another question coming up on this as well. But yes, we'll start with Professor Fallone for a 1-minute follow-up.
Justice Kelly has talked often about he feels he has an obligation when he's come to a different result than prior precedent in his mind as to what he thinks the original intent of the document was. He said many occasions, I've been here with him, where he says he feels an obligation to overturn prior precedent. I think that's wrong. It's wrong because, as I said before, it's dangerous, but it's also wrong because he thinks he knows better than judges who were closer in time to the drafting of the document. People who lived at the time, who came to different conclusions. He's decided he knows better. In fact, when he takes that approach, we don't have our Constitution. He gives us Dan Kelly's Constitution.
I'll take that.
Justice Kelly, here's your 1 minute response. Then Judge Karofsky, we'll get to you after Justice Kelly in 1 minute, if you don't mind.
So first off, I'm impressed to learn that there's a Dan Kelly Constitution. I don't actually have that anywhere near that kind of power. So I work on a collegial court, there are 7 of us. It takes 4 of us to agree to do anything. So this is not about Dan Kelly's Constitution. This is about the words of the Constitution. This is where research comes in. Right? This is one of the key qualities of a good lawyer and a good justice. It's research. And that's most of what we do, is we are looking back in the historical record to find out what came before. My commitment is to following the law as it was adopted at the time, and the words were adopted. And the reason that that's important is because courts can make mistakes. And if you have a slavish commitment to following what the court has done before, that's a one-way ratchet away from the law. It is part of our responsibility to ensure that what we are doing is following the law and not our own personal thoughts, right? So it's actually the exact opposite of what Mr. Fallone is saying. It's not about Dan Kelly's Constitution. It's about the one that was adopted. It's about the one that you adopted and that you have maintained.
And Justice Kelly, thank you. Judge Karofsky, a 1 minute response.
I do understand when when Dan Kelly talks about originalism. I understand the voters and the people of Wisconsin understand that what we have in Justice Kelly on our Supreme Court is somebody who always rules in favor of the right-wing special interests that got him on the court and is working very, very hard to keep him on the court. There is not one example that he is able to give since he has been on the Supreme Court where he has not ruled in favor of the right-wing special interests. So you can call it whatever you want, textualism, originalism, what it is, what he does, what his judicial philosophy is, if you look at how it plays out, is to find in favor of the right-wing special interests every opportunity he has. That is not what I would do. That's not what I do in my courtroom. I follow the rule of law every day, whether or not I personally or politically agree with it.
Thank you, Judge Karofsky. All right, we'll move on to question number 2. And Judge Karofsky, I will start with you this time. This is about legal precedent. This question is twofold. First, what are your views regarding the Supreme Court's responsibility in dealing with legal precedent, and in what circumstances should precedent be overturned?
So I believe that it is incumbent for the Supreme Court, like I said, in order to have stability and in order to have predictability in our legal system, we need to have justices who follow precedent. And so there's an example of 2 cases where the Supreme Court did not follow precedent. The first case was a case that was decided in 2016, it was the Coyne case. And in that case, the Supreme Court made a decision about administrative rules at the Department of Public Instruction. Just a few short years later, in 2019, the Supreme Court ruled 180 degrees the other way. They completely changed what the law was. And the only thing that changed, the only difference between the Coyne decision and the second decision, which is called the Karofsky case, was, as Supreme Court Justice Ann Walsh Bradley says, the only thing that changed was the makeup of the court. So how are people in the state of Wisconsin supposed to know what the law is in Wisconsin when justices on our Supreme Court, and Justice Kelly was on that Supreme Court in 2019 when they changed the decision, when they just changed the decision of what the law is because the makeup of the court is different? If I were on the Supreme Court, what I would do is I would honor precedent, I would follow the rule of law. I would look to those earlier decisions and rely on them. And that is what we don't have, because what we need is we've got to have a court system that is predictable and that is reliable. And not a court system where justices are changing decisions so that it comports with the right-wing special interests that they are beholden to on the court.
Thank you, Judge Karofsky. Justice Kelly, same question. What are your views regarding the Supreme Court's responsibility in dealing with legal precedent, and in what circumstances should precedent be overturned?
Yeah, so we talked about this a little bit already. The primary commitment for a justice of the court has to be to the law, not to ourselves, not to our personal opinions, not to what the court's opinions were in the past. The primary obligation has to be commitment to the law. If it's not, you lose the ability to adopt the laws that control your activities. You lose the ability to live under the rule of law. If judges are slavishly being committed to what the court has said before, rather than what the law says, you lose that ability. Now, actually, Judge Karofsky had just an excellent example of a misunderstanding what precedent is and how it functions. So the Coyne and Koschke cases. In the Coyne case, there was no precedent there. The lead opinion in that case was written by one justice, and no one joined it. And no opinion in that case got more than 3 justices to join it. So there simply was no rule of law that came out of that. As Judge Karofsky must know, you got to have 4 on our Supreme Court to have a rule of law. It takes 4. So there was no precedent to follow there. And the court was obviously fractured about what they thought the law meant. They couldn't come to an understanding of what the law actually was. And she's right. I was on the court in 2019. I was not on the court when the Coyne case was decided. And what I brought to the court was rigorous logic, attention to detail, passion for following the rule of law. And in 2019, we did figure out what it is. And so we got a majority opinion out of that. That's the way that you handle precedent. I know Judge Karofsky doesn't understand that, but that's the way you do it.
Thank you, Justice Kelly. Professor Fallone, same question to you. What are your views regarding the Supreme Court's responsibility in dealing with legal precedent? In what circumstances should it be overturned?
That sounds like a question for a constitutional law professor. Our Supreme Court justices should recognize it's the primary responsibility of the legislature to make policy choices. So when I talk about judicial restraint, that's what I'm saying. The judges should leave these decisions to the legislature in most instances. But we have individual rights, natural rights, expressed in our Constitution that belong to all of us. And sometimes it's the obligation of our justices, as I tell my students, to strap on the armor, get on the white steed, ride out of the castle, and defend those individual rights. One of those natural rights is the right of equal protection, for example. A natural right that we all have to be treated equally by the law, unless the government can come up with a really strong reason why we should be treated differently. And here's where we see precedent getting overturned. Many times Justice Kelly has said, Brown versus Board of Education, overturned, Plessy versus Ferguson. If you follow precedent, then Brown versus Board of Education was wrong. No, not at all. Under the Equal Protection Clause, at first, segregation of the races was upheld by the U.S. Supreme Court. And the government's answer, the reason why segregation should be constitutional was, the races don't like mixing. Social mixing, people just don't like it, and that's a good enough reason to have segregation. By the time we got to Brown versus Board of Education, that was challenged. Explain again why we have to have segregated schools. And the U.S. Supreme Court said that original justification that people don't like mixing of races, that doesn't hold. We saw the same pattern with gender equality, right? Laws that treated women in the workplace differently were upheld because, the woman's place is in the home. That's just the way God intended. But by the time the U.S. Supreme Court got those cases later, times had changed, and the court said that justification, that that's the way God intended it, and women's place is in the home, that's no longer good enough. That's when you overturn precedent.
1 second. Professor Fallone, thank you. Judge Karofsky, I'll give you the first opportunity for a 1-minute response follow-up if you would like.
Sure, thank you. Look, I understand what precedent is, and I understand why it needs to be followed and why it is so important for it to be followed in the Supreme Court, because the Supreme Court is responsible for telling all of us in Wisconsin what the law is across the state. What we don't have right now on the Supreme Court with Justice Kelly up there is someone who's willing to follow what the precedent is. And that is a problem, because then people in this state do not know what the law is. I am committed to following precedent. I am committed to making decisions based on the rule of law. And that is what people in the state of Wisconsin deserve on their Wisconsin Supreme Court.
Thank you. Justice Kelly, a response?
Thank you. I think Mr. Fallone's answer is better than Judge Karofsky's in that.
Thank you. Thank you.
You're welcome. It really was. The reason Judge Karofsky is wrong about this is people know what the law is by looking at the law. The law. We are supposed to clearly explain what the law is, but if we get the explanation wrong, then we have to fix that. A slavish devotion to precedent just propagates error. So the one, I take a quibble with you, Mr. Fallone, on Brown versus Board of Education and Plessy. The overturning of Plessy was not correct because the justifications undergirding Plessy had changed. Plessy was wrong in the beginning. That was a wrong decision. The court did not follow the Equal Protection Clause. So when Brown versus Board of Education came along, it wasn't looking at changed justifications and deciding whether people have given an adequate reason for why we should have equal protection. They looked back at Plessy and they said, oh yeah, we get it. That was just wrong, and we got to stop doing the wrong thing.
Thank you, Justice Kelly. All right, let's move on to the third question, and Justice Kelly, we'll start with you this time. Get your microphone over here. To what extent do you believe the Supreme Court should defer to the actions of the legislative or executive branches?
Yeah, so there's a couple of questions bound up in that. Generally speaking, and this is where Mr. Fallone and I actually do have some agreement. Generally speaking, the court should be deferring to the legislature. They're the branch that makes the laws, decides what laws are going to contribute to human flourishing. The policy decisions belong to them. The work that we do actually follows what they do. So we take their completed work and apply it to the cases in front of us to come to our judgment. So when it comes to a policy decision, we should always be deferring to the legislature because that's their authority. The only area in which we don't defer to them is deciding whether what they did is compliant with the Constitution. That's our responsibility. So we lay the two side by side, and this is a doctrine that goes way back to the 18th century. This is the proper approach to constitutional adjudication. You take the law that the legislature made, you lay it alongside the Constitution, and if you can apply them both, you apply them both. But if there's a contradiction between the two, then you have to figure out, well, which one do I apply? And in that context, the Constitution always comes first. Right? So in that circumstance, and only in that circumstance, do we not defer to the legislature. In the executive branch, the executive has its own authority. They decide how to carry out the law. And we defer to them, and again, unless and until the way they carry out the law violates the Constitution.
Thank you, Justice Kelly. Professor Fallone, same question to you. To what extent do you believe the Supreme Court should defer to the actions of the legislative or executive branches?
Well, this is a question that really, I think, illustrates my profound disagreement with Justice Kelly and some of his approach to his job. And it really comes down to the question of, should the court defer to an agency of the executive branch, like the Department of Natural Resources? Our legislature passes laws, and we have agencies, like the DNR, that in enforcing the law, they have to interpret it. And so they come up with their own reading of the law. And sometimes that's challenged, the enforcement is challenged. Someone says, the DNR got it wrong. and then it gets in front of our Wisconsin Supreme Court. And the court had precedent saying that, well, we should defer to the agency's interpretation of its own law. It has the most experience with it. It applies it all the time. As long as it's a reasonable interpretation, we'll defer to it. But there are folks who don't like agencies, and they have an agenda, and even some of the parties who started a case, they called this their crusade a revolution. They wanted a revolution in administrative law. They wanted to overturn these cases that allowed for a deference to agency decisions. And that's in fact what Justice Kelly did in a decision called Tetra Tech. And he ruled that the Supreme Court does not have to defer to the agency's interpretation, that they can decide for themselves. And that's fine if they want to. But he did something else. He didn't just say, we've changed our mind because we have a better idea. He said, it's Article 3 of the Constitution. It's the constitutional role of the courts that prohibits us from deferring. Because he wanted to create a constitutional rule that wouldn't just decide that case, but that would prevent any future courts from ever deferring to agencies as well. That's an example of what I'm calling when Kelly goes out of his way to interpret the Constitution and leave us with Dan Kelly's Constitution.
Thank you, Professor Fallone. Judge Karofsky, I'll turn it over to you. To what extent do you believe the Supreme Court should defer to the actions of the legislative or executive branches?
Look, I think the judiciary is and should be an independent branch of our government. And it is important, it is incumbent on the judiciary to make sure that the other two branches do not overstep their power. What we have on the Supreme Court right now, though, is justices, Dan Kelly as a justice, who is always finding for the Republican legislature. And the problem right now is that they're not even waiting for these cases to percolate in a circuit court and then to work its way up through a court of appeals so to get to the Supreme Court. They're not allowing evidentiary hearings to happen. They're not allowing for discovery. They're not allowing for a trial. They pluck these cases like the lame duck case and like the budget veto case. They pluck these cases as quickly as they can so they can make the decision that they want to make in favor of the Republican legislature as quickly as they possibly can. And that is what feels like corruption to folks in the state of Wisconsin. What I would do as a state Supreme Court justice is I would allow the process to play out. I would allow trial courts to do what I do every day, which is to hear evidence, to apply the law fairly and equally and impartially and respectfully, to let a record develop and grow so that when the case gets to the Supreme Court, you have a robust record. That's not what we have today, and that is what we need in a justice on our Wisconsin Supreme Court.
Thank you, Judge Karofsky. Justice Kelly, a 1-minute follow-up response if you'd like.
Yeah, so I find it profoundly regrettable that Judge Karofsky is, and she's done this frequently. I've had to call her out in the past on her lies and her slander. And unfortunately, I'm going to have to do it again tonight. Because it's nonsense that I rule in favor of certain interest groups, that the court is corrupt. It's an ugly, vicious slander. And she's lying. There's absolutely no basis for this. Now, I've gone into this in detail at the last board, the Milwaukee Bar Association. You can look at the video there. And I had to take her to task for it there, because this kind of behavior is beneath contempt. This is completely inappropriate behavior for a jurist. It's unacceptable. She simply lies and slanders so that she can destroy the people in her way to fill her craving ambition. And I've had it.
Thank you, Justice Kelly. Professor Fallone, a 1-minute follow-up response if you would like.
I'm Mexican-American. My father was a school teacher. My mother was a Mexican immigrant. And as a Mexican-American, I often I get upset if people make broad generalizations about Mexicans. They're all like this, they're all like that. And one of the things, I think I have an obligation. If I'm upset when people make broad generalizations about Mexicans, I should be upset anytime people make broad generalizations of any group, right? I have been running a non-political campaign. And my opponent likes to talk about us versus them, one side versus the other, Republican versus Democrat. I'm running for the Wisconsin Supreme Court because I don't divide it into us versus them. I want to be a justice for all of Wisconsin voters. And that's my approach. And I absolutely reject attempts to divide us in this race. That's not the court's job. And I'm going to end the politicization of this court.
Thank you, Professor Fallone. Judge Karofsky, a 1-minute response follow-up for you.
Well, it's pretty clear that Dan Kelly's getting hot and bothered that I'm calling him out on this. But not only is the truth a complete defense to the allegations that he's throwing my way, but he has not offered one example of a time when he has ruled against the right-wing special interests. My claim is simple. It looks like corruption to people in the state of Wisconsin, despite his high and mighty rhetoric. It feels like corruption when they can see with their own 2 eyes that he always rules for folks on his side of the political aisle. And they are now plucking these cases so that they can more quickly and with less scrutiny accomplish their goals. This is completely different from the way I have handled this. I have been honest about my values. I've talked about what I believed in. And Dan Kelly is saying that he can't talk about his values, but there he is, standing in front of a huge Trump sign, cradling an AR-15 so he can send a signal about his politics going forward.
Thank you, Judge Karofsky. All right, let's move on to question 4, if everyone is ready for that. Professor Fallone, we'll start with you this time. This one has to do with recusal. In what circumstances should a Supreme Court justice recuse oneself? Is the appearance of partiality a basis for recusal?
Yes, the appearance of partiality is a basis of recusal if the judge or justice in their own initiative decides to step down. What we need is to reform the rule that requires judges to step down in certain instances. And look, I talked about this in 2013 when I ran for the Wisconsin Supreme Court. It was a key part of my platform then. It's a key part of my platform now. I've worked on it in the years since. I've done public speaking with the League of Women Voters to educate the public on the issue. And I made even a video with Common Cause Wisconsin talking about this issue. If you are a party in a lawsuit and you lose, and you walk out of that courtroom and you don't know whether you lost because of the merits of the case or because opposing counsel or the opposing party had made major campaign contributions to the judge, you've got doubt in your mind. And that doubt is toxic to our justice system. We have a very simple remedy here. Just adopt a rule that any party or independent group that spends $10,000 or more to elect a judge within a couple years of the election, if they're actually a party in the case, that judge has to step down. It's just that simple. There are not a lot of people in Wisconsin that donate that much money. Very few people would be affected. If you donate more than $10,000 in a Supreme Court race, please talk to me after the forum. Here's the thing where Justice Kelly and I differ profoundly. He will talk about free speech. He'll talk about the right to spend money to elect whoever you want. I don't oppose that. But you can donate to whoever you want. You can help elect whoever you want. But you do not have the right to choose the judge to be on your case. That's totally different.
Thank you, Professor Fallone. Judge Karofsky, same question to you. In what circumstances should a Supreme Court justice recuse oneself? Is the appearance of partiality a basis for recusal?
Absolutely, and that's in the Wisconsin statutes. A judge or justice in Wisconsin is to recuse ourselves if there is a conflict or if there is the appearance of impropriety. I have done it myself in cases in circuit court here in Dane County. Look, what we need in Wisconsin is a very clear recusal rule. We need a bright line so that if donations come in above that line, judges and justices are not going to sit on that case from the contribution from that party. That is what is fair to voters in this state. That is what is fair to citizens in this state, it's what's fair to candidates, it's what's fair to judges, and it's what's fair to justices. Without that, it does not feel like these elections are fair. It doesn't feel like it is the people. What happens is you have people who are donating to these campaigns, you have justices getting on the Supreme Court, and then you have justices ruling in favor of the people who paid a lot of money to get them on the court. The Supreme Court had an opportunity when Justice Kelly was on the court to sit down and to have a hearing so that they could get information and they could craft a really smart rule. They didn't even hold a hearing. They didn't even allow people to come in to say, look, this is what the rule would look like. If I were on the Supreme Court, I would pull together people so that we could craft a rule. It's incumbent on the Supreme Court to do that because they are the leaders of the judicial system. And they need to pass a smart rule. And once in a clear rule, that's what's fair to everyone in Wisconsin. And if I were on the Supreme Court, that is what I would push for.
Thank you, Judge Karofsky. Justice Kelly, same question. In what circumstances should a Supreme Court justice recuse oneself? Is the appearance of partiality a basis for recusal?
Yeah, I think that any time that there's a case in which we have a conflict of interest, you have to recuse yourself. If there's any opportunity for an outside influence to direct how the decision is going to be made, you need to recuse yourself. And the appearance of impropriety is definitely a basis for recusal. So I'd like to take the rest of my time, though, on again, just pushing back on this ugliness that Judge Karofsky has brought this campaign. She's made this the backbone of her campaign. If she didn't have slander, she wouldn't have anything to talk about. I want to tell you why, and she wonders why I get a little hot under the collar when she calls me and my colleagues corrupt. Let me explain that a little bit. When I was growing up, our family didn't have much. My dad sometimes had to work 3 jobs, keep a roof over our head and food on the table. When I was a young man, he pulled me aside one day and he said, Dan, when I'm all done here, I probably won't have much to leave you. But I promise you this, I will leave you a good name. And when he was all done, he didn't have much to leave. A broken watch and a Remington statue. But what he did leave me was a good name. He kept his promise. And that's all I have of my dad, is that legacy. Now, I am absolutely committed to passing that legacy down to my children. And all of my career, all the breadth and the depth of the work and the commitment to the rule of law in this state and for the people of Wisconsin, no one ever has called my honor or my integrity into question until she decided to do it to fulfill her craven ambition. That's her. I will not have my honor or my integrity called into question by a careless judge who doesn't care who she has to destroy to fulfill her ambition.
Judge Karofsky, I'll let you have the first 1-minute response to that because I'm sure you have something to say as well.
Well, thanks, I do. And what I was starting to say before is that I think that there's a sharp contrast between the way I am explaining how I rule in my courtroom and the way that Dan Kelly's track record bears out. I have been honest about my values, I talk about what I believe in, and I've also given many examples when I rule against what my own personal beliefs are. I did it last week in a case where I had a case in my courtroom where there was a felon in possession of a firearm. I don't want felons to have firearms in this state, but the police officer did not have a reason to pull that person over. I dismissed that case. We do not see that in Dan Kelly. What he does is he ignores precedent, he gets to the result that he wants, and it's like magic. He claims it's logic, but what it is it's like our teenagers arguing. The facts don't enter into the equation. The claims of slander that he is making against me, this is just an attempt to distract from what is the real issue in this race, and that is that people feel like there is corruption on our Supreme Court.
And Justice Kelly, I'll give you a response once. Yes, let's go with Justice Kelly, give you a chance to respond, and then Professor Fallone will come back for your 1-minute response. Is that okay with you? Or do you want to go first? I'm not asking, I'm going to say. Justice Kelly will then battle this out, and then I'll let you give your 1-minute response to the recusal.
So here's one thing that you'll notice about her saying. She never identifies a case where there's an error in the logic or the law. This is our responsibility as jurists. If there is an error that I've made in an opinion that I wrote or that I joined, that is fair game to look at that opinion and identify an error in the law or the logic. See, that's what jurists do. That's what jurists do. Political hacks look at the end result and they say, that doesn't agree with my politics and therefore the opinion must be wrong. Jill Karofsky goes through and she totes up the score of cases that she doesn't personally agree with, and she calls those corrupt. But she's never once bothered to actually do the job of a jurist and look at the opinion and try to identify any error. That is a fundamental abnegation of the jurist duty.
All right, let's give Professor Fallone the final word on this. You want to comment on that, or the original question about recusal?
Somewhere in all of this, someone said teenagers arguing. That's the only thing I agree with. As they talk back and forth, you said this, you called me that, they're talking about themselves. Right? I'm running this campaign to talk about you, all of you, and about what we need on the Wisconsin Supreme Court. I am a law professor who has stood up for the rights of protest in the state capitol that we all enjoy, who stood up for the right of equal protection, that all should be treated the same without regard to their religious faith. Right? I am the I'm the candidate who has spent over 2 decades in the nonprofit sector, leading organizations that provide low-cost lawyers to working families so they don't have to go to the courthouse on their own. These are issues that matter to you, and I'm running to be that voice on the Wisconsin Supreme Court.
Thank you, Professor Fallone. I haven't been watching the clock too closely. Tim, do we have time for the additional question? No, Tim's telling me no. Okay, so we will go on to the 5th and final question. Again, you'll each have 2 minutes, a 1-minute response, and then we'll go into the closing statements. Judge Karofsky, let's start with you this time. Here is the question. Many people believe the judiciary has become too politicized. Fitting question to end on, possibly tonight. How will you ensure an independent, nonpartisan Supreme Court?
Look, I think we need to start out with why this race is so important. And it's so important because of the types of cases the Supreme Court's going to hear in the next few years. For instance, gerrymandering. The legislative lines are going to be redrawn, and this Supreme Court is going to rule on a case that is going to impact the state of Wisconsin for the next 10 years. I am the only person in this race who has a track record for following the rule of law every day in my courtroom. I presided over more than 1,700 cases last year, and in every one of those cases, I followed the rule of law. I treated everyone in my courtroom fairly and equally and respectfully, and that is what I will do on the Supreme Court. What we have in a justice like Justice Kelly is someone who 100% of the time finds in favor of the right-wing special interest that got him on the court. He has decided, I think it's 6 times on cases involving Wisconsin Institute of Law and Liberty, and every single time he's found in their favor. We saw him pluck the lame duck case up. We saw him pluck the budget veto case up. He is not able to give an example of a time when he has not ruled in favor of the right-wing special interest the entire time he's been on the Wisconsin Supreme Court. So as the only person in this case, only person in this race who has a track record of following the rule of law, who watches the law play out in real people, the way I would get politics out of these races and out of the Supreme Court is, first of all, I'd pass a really good recusal rule. Second of all, I would continue to make my case to the voters of the state of Wisconsin that what they need on the Wisconsin Supreme Court is a judge, is a justice who has a track record of following the rule of law. And that is what I show, that is what I have been doing, and that is what I will do on the Wisconsin Supreme Court.
Justice Kelly, do you have the microphone, or which? Oh, there we go. Thank you. Same question. Many people believe the judiciary has become too politicized. How will you ensure an independent, nonpartisan Supreme Court?
Same way I have been since 2016. It's the process of the way that we do our job. So when you consider a case at the Supreme Court, our responsibility is to apply the law with rigorous logic to the case in front of us. So we start with the premises, that's the law applicable to the case, and then using that rigorous logic, we apply it and then come to the conclusion. And when you're done, if you can go back and show that there is a unbroken chain of logic between the premises and the conclusion, then you can be confident that the conclusion is required by the law and not by your personal politics. That's what I've been doing since 2016. I think that's really the only way to do it, because as it turns out, logic doesn't care about your politics, right? So now, Judge Karofsky is, I think I'm finally starting to understand what the fundamental problem is with her allegations. She identifies the Wisconsin Institute of Law and Liberty as being a right-wing organization for which I've always ruled. And she's mistaking parties for lawyers. The Wisconsin Institute for Law and Liberty is a public interest law firm. They bring cases to our court, cases on behalf of parties. They're not, we don't rule for or against Wisconsin Institute for Law and Liberty on anything, because they're not a party. We rule for or against people they represent. And that's based on the law and on the logic. And unless and until you can identify an error in that logic or an error in that law, and I just completely reject this ridiculous accusation that I rule for organizations. I rule for the law every single time.
Professor Fallone, same question to you. Again, many people believe the judiciary has become too politicized. How will you ensure an independent and nonpartisan Supreme Court?
This is, make no mistake, the most important issue in this race. The job of our courts is to make sure the two political branches play fair and abide by the constitutional system. We expect division and fighting in Congress or state legislature and the governor's office and the president's office. We know politics gets in there. But the court has to be the neutral arbiter to say everyone plays by the same constitutional rules. And when the court becomes politicized, when the court cares who's winning and losing the political battles, it doesn't play that role, and now the rest of us are in trouble. The way to keep politics out of the court is to have candidates who don't run political campaigns. From day one, I've been the candidate who has refused to engage in any partisan attacks. I've refused to characterize any Wisconsinite as being on my team or the other team. I did not ask the Republican Party to help me in my campaign. And Justice Kelly, you should not have asked or accepted the help of the Republican Party. I am running an independent campaign. I have a track record, 30 years of fighting on principle. I don't care who wins or loses. Never have. You can go to FalloneForJustice.com. You can see everything I've written for 30 years. It's on the website, full transparency. I stand for principle. I stand for the right of free speech. I don't care who you are. I stand for equal protection under the law for everyone, not just for some. I stand up on principle. And you know what you're going to get with Ed Fallone on the Supreme Court. Not someone who looks at us as being in different camps or different tribes. It's someone who's going to be a Supreme Court justice for all of us.
Thank you, Professor. Judge Karofsky, I'll give you the first opportunity for a 1-minute follow-up response if you'd like.
Well, thanks. I'm the only person in this race who isn't using the Democratic State Party or the GOP State Party to run my campaign through their offices. Justice Dan Kelly has his office, his campaign office. He's running it through the state GOP office. He has been standing in front of big Trump signs. When Donald Trump was in Milwaukee just last month, he publicly endorsed Dan Kelly for the Supreme Court. I have a track record of being a judge who follows the rule of law, even when I do not personally or politically agree with it. I believe sometimes there are cases in my courtroom where I believe that in, for instance, drunk driving cases, that we should tell jurors if it's a person's fourth or fifth or sixth OWI when they are sitting on those cases. But the law commands that I don't, so I don't do that. I could give you examples all day long where I make decisions on the bench that go against what my political beliefs are. And we just don't have that in Justice Kelly.
Thank you, Judge Karofsky. Justice Kelly, a 1-minute follow-up.
So, when I say that I just follow the law and not my personal beliefs or politics, you can accept that or perhaps not. But there is independent, third-party verification that what I say is true and what Judge Karofsky says is not. So there's a professor at Marquette University who runs a website called Scalstat Blog, and he studies the opinions of the Supreme Court. It's not Mr. Fallone. He studies the opinions of the Supreme Court and the areas in which he's interested, and he studied my opinions in particular. And he did it specifically for the purpose of determining whether or not my politics influenced my decisions. And his conclusion was that there's no necessary correlation between the opinions that I write or join and my personal politics. That's independent, third-party verification of what she says is false. And he went on to call me a maverick because of that. He called me a maverick because what Judge Karofsky says is false.
Thank you, Justice Kelly. Professor Fallone, your 1-minute response.
When Justice Kelly had his nomination papers, we all have to get 2,000 plus signatures to make the ballot. When Justice Kelly had his nomination papers returned to people who were getting signatures, they mailed them to the Republican Party headquarters. And I read in the newspaper today, I haven't verified it, but I read in the newspaper today that he's opened a campaign office in Milwaukee, the Republican Party headquarters there. I have never, ever sought or accepted help from a political party. It's wrong. I recruit my own staff. I pay my own staff. It's not easy. Yeah, it would be very easy for me to just go to a political party and say, hey, lend me someone. You know, give me an office space so I don't have to pay rent. It's harder that way. But I do it because I'm independent and I want to stay independent. There seemed to be a suggestion in Judge Karofsky's last answer that she said she was the only candidate who hasn't accepted help. I've accepted no help from any political party. And I think that that was just a loose comment by her.
Thank you, Professor Fallone. All right, we are ready to move into the closing statements. You will each have 2 minutes for your closing statements. I would encourage you to say what you hope everyone here tonight, and those who will be watching this at a later date, because the link will be available, what you would like them to take away from you and how you would like them to remember you, why they should vote for you for the Wisconsin Supreme Court. Justice Kelly, we will start with you for the first 2 minutes, then we'll go to Judge Karofsky, and I will give Professor Fallone the final 2 minutes of the night.
Well, thank you all again for being here. This all, I think, could be neatly wrapped up in terms of a question I was asked by a 13-year-old student a couple years ago. I was doing a program, and at the end of it, I took some questions, and he stood up and he looked me dead in the eye, and he said, "Who's your boss?" It's the greatest question I've ever been asked. And it's the greatest question because it really defines the proper relationship between the people of Wisconsin and the governments that they create and maintain. And that's because all of the authority to create and maintain governments belongs to you. To you. You just loan it to us. All the authority to be exercised is on loan. And so we are to do that in trust and on your behalf and for your benefit. And that's what I've been doing since 2016. And the way that I do that is by being faithful to the Constitution that you have adopted and maintained, and looking at the text and looking at what you've asked me to do. Just exercise the judicial power. Don't make the laws, don't ignore the laws, don't play favorites with the law. Just apply the constitutional text and the statutory text faithfully and with rigorous logic to ensure that the conclusions that we reach are mandated by the law and not by our personal preferences. Now, I'm the only one in this race who can say, check my work. I've been doing this since 2016. I've heard thousands I've reviewed thousands of your cases. I've heard hundreds of arguments, and I've written opinions on some of the most consequential cases in the state. I invite you, look them up. Check my logic, check the laws. Ensure that I've been a faithful servant to you. And I'm confident that when you do, you will find that I have followed the law in every single case. Thanks so much for being here.
Thank you, Justice Kelly. Judge Karofsky, your closing statements.
Thank you again for listening to me tonight via video. I know, again, that it wasn't ideal, but I really appreciate the opportunity to be able to talk to you about why I am in this race. What I am bringing to this race is my experience. I have a depth and breadth of experience that my opponents can't touch. I presided over more than 1,700 cases last year. I'm a trial court judge right now. I oversee cases of criminal law. I see civil law cases, injunction cases, and small claims cases, and eviction cases, and a number of family law cases as well. I've also been a prosecutor. I spent many years as a prosecutor helping women and children who were victims of crime. I was Wisconsin's first violence against women resource prosecutor. I was also the head of Wisconsin's Office of Crime Victim Services, helping victims in every single county in this state get the help that they needed. I have experience in the civil law. I was general counsel at a national organization, and I've also been a law professor at Wisconsin's only public law school. That's the experience that I am bringing to this race. I have spent much of my career on the front lines of our justice system. I've spent much of my career seeing how the law impacts real people every single day. That is the experience that I'm going to bring to the Supreme Court. In addition, I'm going to bring my values, my Wisconsin values. I'm born and raised in this state. I'm a single mom of 2 teenagers. We all went to public schools. I talk to my kids about the importance of workers' rights and women's rights and human rights and civil rights. The third thing I'm bringing to this race, in addition to my experience and my values, is my energy. I was a state high school tennis champion. I was a D1 athlete in track and cross country, finished the Ironman triathlon 2 times. I've never been outworked or out-hustled. I'm very excited to be in this race. I'm not going to be outworked or out-hustled in this race. We are going to run a strong campaign all the way through April 7th. People are excited about our message. Thank you.
Thank you, Judge Karofsky. And Professor Fallone, your closing statements.
You know, we get to the voting booth and we look at the Supreme Court candidates. And we ask ourselves, how did we get these 2 candidates? And don't I have another choice? Well, guess what? February 18th, you have a choice. I'm a different kind of candidate. I said at the beginning of my opening statement, I fight for the underdog. I think that's because my father was a public high school teacher, taught high school English. He met my mother in Mexico City. They got married there. He brought her back to the U.S. They raised 4 kids. We didn't have much money. We were a working family. We weren't poor. But there certainly was no money for college. The only way I was able to attend college and law school was because I got an academic scholarship. And I graduated top of my class from one of the top law schools in the country. And then I worked at a major law firm, working on $350 million lawsuits, defending corporations in giant national FBI investigations. And I figured out after 4 years, why am I doing this? That's not what I want to do. So I quit my job, and my wife Heidi and I moved to Milwaukee. And there, we raised our children, and I've been teaching at Marquette Law School for 27 years. Constitutional law, criminal law, business law, to 2,300 Wisconsin lawyers, many of whom are now judges and prosecutors and defense attorneys. But that's not all, because I never forgot where I came from, a working family. So I've led nonprofit organizations that help working families get affordable lawyers in family law cases, in immigration cases, landlord-tenant cases, misdemeanor cases, so they don't have to go to the courthouse alone, because I never forgot where I came from. Look, we don't need 7 judges that are exactly the same on the Supreme Court. Isn't there room for a law professor who stood shoulder to shoulder with working families? Think about the kind of justice you want to see on the court representing you. You might think of Justice Shirley Abramson, who just retired after 4 decades on the court, nationally recognized as one of the greatest state Supreme Court justices in our nation's history. What was her experience? She was a law professor. She never spent 1 day as a trial judge. You have a choice.
Thank you, Professor Fallone. And I want to thank all of our candidates, Justice Kelly, Professor Fallone, Judge Karofsky. Thanks for making the time to still join us, even though it's by video, but we appreciate your attendance as well. So thank you to all three of you for being here, and thank you to you for being here as well. And I certainly hope that you learned something about each of the candidates that you can take with you to the polls, be an educated voter, again on February 18th. 2 weeks from tomorrow, the primary, and then it will be narrowed down to 2 at that election to April 7th. Best of luck to each of the candidates and the rest of your campaign ahead of February 18th and then again on April 7th. Thank you so much for being here tonight. I'm going to turn it over to Tim for some final words, and it looks like you're doing a pretty good job of ending on time. Tim, that's what most people care about, right?
I don't know about the rest. Wow, that was pretty intense, wasn't it? I want to thank Danielle for a fabulous job moderating.
Just to help ease the tension a little bit.
I want to thank all three candidates for participating in the forum tonight. I want to encourage all of you to follow up their comments with further research, find out more about all the candidates, be the most informed voter you can be. Show up for the primary on February 18th, show up for the general election on April 7th. I want to offer a few other thank yous before we end it for the night. So I need to thank our co-sponsors again, the League of Women's Orders of the Greater Chippewa Valley, the Center for Applied Ethics, the Scout Student Association, and the Honors College. I want to thank Nick Danger and his staff for a lot of work setting up the technology, getting everything to work well tonight, so give them a hand. I want to thank my office staff at the Menard Center for the Study of Institutions Innovation, in particular Ellen Carlson, who's put in an enormous amount of hours getting this set up, and tonight, and I want to thank Grace Stolen, who helped with a lot of aspects of this, Kelly Gardner, Emily Schaefer, and Olivia Kruger also helped. So, thank you very much for coming out.